Welcome back to a new post today, and let's continue with week 2 of Polity for Governance for the week gone by for the dates January 7th to 12th. In the last session I had done January 1 to 6, so we have many important issues coming up with regard to language status, classical language, the local body elections. Apart from that, the Law Commission giving a strategy for the One Nation One Elections polls, and apart from that we have FCRA and many more issues to discuss. So let's get quickly into the topics without wasting much time. So the very first thing is about the Kashmiri language. Let me tell you that every state has its own official language and the set of languages spoken as well. So according to Jammu and Kashmir Union Territory, the official languages are Kashmiri, Dogri, Urdu, Hindi and English. We also have an official language for the Government of India, that's English and Hindi in Devanagari script. Every state also has a similar. Apart from that, the spoken languages are Kashmiri, Gojri, Pahari, Punjabi, Badarwahi, Sarazi, Kowar, Sheena, Burushakshi and Betari. Now the Microsoft Translator and the Google Translator has now showed interest to include Kashmiri language in the translator, and in 23 an online campaign was to get the Kashmiri language included into the Google Translator as well. This demand has been accepted. Kashmir has a very rich tradition, heritage and literature and has fascinated many people across the world. Now the Kashmiri language is going to get a new lease of life because of the Microsoft Translator and the Google Translator set to include the Kashmiri language into the translator tool. This means that the Kashmiri language literature would be accessible to the people across regions and languages. Now, and according to a recent report, only 5% of the native Kashmiri people can read the Kashmiri script. With the Microsoft Google translators incorporating the language, it will help the people across the regions and nations to access the Kashmiri literature from across the world. Now, Kashmiri writers say that it will help them broaden their reach and writings, and it will be accessible to all across the world. Let me tell you that part 17 of the Constitution deals with official language, and we have certain provisions with regard to development of Hindi language as well. Now, recently Government of India passed in 2020 the Jammu and Kashmir Official Languages Bill, which included Kashmiri along with Dogri, Urdu, Hindi and English as one of the official languages, and therefore a big boost to the Kashmiri language. Now, the law panel examining various formulas on simultaneous polls has given a strategy. It said the possibility of carrying a 3-tier voting exercise or elections in 2 phases in a year. Now, in the first phase, it said that the Lok Sabha and the state legislative assemblies can be held, and in the second phase, the local body polls can be organized. And this is one of the formulas that is being cited by the law panel considering simultaneous polls in the country. In 2018, previously the Law Commission endorsed the government's proposal for holding simultaneous elections to Lok Sabha and state assemblies, but there was no local bodies included. Now, the Law Commission is looking at a 2-phase elections which include the Lok Sabha and elections in the first phase and the local bodies in the next phase. A present law panel under Rituraj Avasthi is finalizing a report on holding elections to the Assembly and the Lok Sabha together, but a high-level committee has been formed by the government on One Nation One Election under the former President Ramnath Kovind, which is tasked to recommending how exactly the Lok Sabha, Assembly and the local body polls which are called as the Panchayat municipalities can be held together. So let me tell you that keeping in mind the terms of reference, the Kovind-led panel commission has enhanced the ambit to study not only now Lok Sabha and Assembly elections but also holding local body elections simultaneously. And very much related to this use is that J&K local body terms of Panchayat has come to an end. Now, we know that Article 370 was scrapped in 2019 and it was turned into Union Territory. The last time the local body elections were held in Jammu and Kashmir were in 2018. There are almost 30,000 local body representatives, but the centre says that the local body elections will be taken up only after delimitation. And let me tell you, there is a time-bound period of 6 months after which the local bodies have to be constituted after every 5 years. Now, J&K partially adopted the 73rd Amendment Act of 1993. Let me tell you, in India, local bodies are divided into 3 types. They are urban local bodies, rural local bodies and traditional local bodies. There are 8 types of urban local bodies like municipal corporations, municipalities, notified area committees, town panchayat, cantonment board, municipal council, city municipal council council and town municipal council, there are about 3 types of rural local bodies: district panchayat, intermediate panchayat or mandal panchayat, and your zilla parishad, gram panchayat, or village panchayat. And they are traditional bodies of 13 in time. Few of them are autonomous district council, village council, tribal development autonomous district councils, block advisory councils, etc., which are constituted under the various 5th and the 6th schedule and also the PISA Act as well. Now, Supreme Court is hearing had heard the Bilkis Banu case of remission of the convicts, and it cancelled the remission of the 11 convicts. So the court looked into the grounds of remissions, whether they followed the uniform standards. And let me just look into the issue. So yes, so the Supreme Court squashed the premature release of the convicts who were given remission by the state of Gujarat, and it said that the state government of Gujarat was not the correct one to give the remission, and instead the state government of Maharashtra, because the trial had happened in the state of Maharashtra, and remission was squashed, and it said that Gujarat had actually usurped the power of Maharashtra. The court held that the convicts were tried and sentenced in Maharashtra, and it was only Maharashtra who was the correct authority to remit their sentence. Now, Justice Nagaratna in the case said that Gujarat had usurped the power of Maharashtra, and the order of the remission was in favor of the convicts. Therefore, we strike out the remission because of usurpation of power, and Gujarat has no jurisdiction at all to give the remission. This was what the Supreme Court said. Now, let me tell you that apart from the Articles 72 and 161, even the CRPC also deals with the power of remission, and it was and the CRPC under Section 432 itself says that the Gujarat government was not the appropriate government under which the remission was given. Now, it said that the petitioners had argued that the trial judge in Mumbai and the CBI, which was the prosecuting agencies, had disagreed with the proposal of release of convicts. Let me tell you that the Supreme Court had cancelled the remission of these 11 convicts on various grounds, like violating the CRPC provisions and also the manner, the nature of the crime that was committed as well. And the next most important issue is with regard to delisting of the cookies and the zombies from the ST list. The criteria used by the government to declare STs were adopted by the local committee recommendations in 1965, and these are used also till today. So there is a party or a group that is recommending to delist the cookies and the zombies from the scheduled tribe so that the Metis can get into the scheduled tribe list. Now, let me tell you that it is the President of India which releases a constitutional order with respect to every state for inclusion of tribes into the scheduled tribe list under Article 342 of the Constitution. And the primitive and the characteristics for which a tribe shall be qualified to be a scheduled tribe is our primitive traits, distinctive culture, geographical isolation, shyness of contact with the community at large, and also backwardness. Now, the Manipuri government was asked by the centre to examine the representation seeking the deletion of the nomadic Chin and the Kuki from the scheduled tribes list of Manipur. The Union Ministry said that Maheshwar Taunojam, who is the National Secretary of the Republican Party of India, had made a representative to the centre saying that the Kukis and the Chin should be removed from the scheduled tribe list so that the Metis can get the representation in the scheduled tribe list. And this was one of the main reasons why we had a civil commotion in the Manipuri state as well. Throughout 2023, Metis group in Manipur made representatives seeking inclusion into the scheduled tribe list, and there was an appeal from one association, Metis Pangals, as well. It was the first time that in the state of the Manipur especially, it witnessed ethnic conflicts between the Metis and the Kukis, because the High Court had given the directions to the state government to recommend the inclusion of the Metis in the scheduled tribe list, which are maximum in population, while the Kukis do not want the Metis to be included in the scheduled tribe list. So there is one representation made by this secretary, Taunajam, who is the National Secretary of the Republican Party of India, and he says that the Kukis and the Zomis should be removed removed from the scheduled tribe list so that the Meiteis can get included in that. So these are the criteria, and apart from that, I told you how because of the scheduled tribe demanding status for the Meiteis, there was a ethnic conflict in Manipur, so much so that it was thought to come under President's rules as well. Now Supreme Court said that it will have to form a bench now to hear the case with regard to a collegium system. There is a plea challenging the collegium system for appointing the judges, and let me tell you that it was in 2014 the then NDA government enacted the National Judicial Appointments Commission Act, seeking to give executive more say in appointment of the judges. And according to the National Judicial Appointments Commission, the 6th member would comprise the CJI, that is the Chief Justice of India, 2 most senior-most judges of the Supreme Court, a law minister, and 2 eminent persons chosen by a selection committee made up of the CJI, Prime Minister, and the leader of the opposition, to include the names to be chosen as the judges of the Supreme Court and the High Court. Now the Supreme Court told the petitioner that who was challenging the collegium system that it will have to constitute a bench to hear it. Let me tell you that very recently in 2015 the Supreme Court, in a judgment 4:1, struck down the National Judicial Appointments Commission, making very clear that judicial appointments will be continued to be made by the collegium system that was formed by the three judges case. It is not a constitutional body, but it is a Supreme Court intervention mainly formed to clarify the meaning of the consultation of the President with the Chief Justice and other senior most judges according to Article 124 of the Constitution. And therefore, while scrapping down the National Judicial Appointments Commission, the Supreme Court said that the NJAC would impinge on the judiciary separation of powers because it included the executive and violate the basic structure of the Constitution. So the basic independence of judiciary is one of the basic structures of the Constitution, and therefore the NJAC would violate the basic structure of the Constitution, and it is on this premise that the NJAC was scrapped by the Supreme Court in 2015 and reverted back to the old collegium form of system of appointments, where the names are decided by the Chief Justice of India along with 4 senior most judges of the Supreme Court, formed on the basis of the 3 judges case to decide on the appointments and the transfers of the judges of the Supreme Court and the High Court. Now the ruling said it assumed to be that independence and integrity of the judiciary is of highest importance, and not only to the judges but also the citizens seeking resort from the court of law against the high-handed and illegal exercise of power by the executive, and therefore the Supreme Court said that it has to form a constitution bench. Now, do we have the provisions with regard to constitution bench in the Constitution? Yes, we do have it under Article 145. Now the power to form a constitution bench rests with the Chief Justice of India, who is the roster of the cases, that is, he decides which bench will decide which case. And also there are 2 conditions in which a constitution bench is formed. That is, the constitution bench should have at least 5 judges, and the largest such bench until recent was the Kesavananda Bharati bench, which decided the case in 1973, and it had 13 judges and also came up with the principle of the basic structure of the Constitution. Now going back to what cases can be decided by the constitution bench, they are that the case should involve a substantial question of law for interpretation by the court, and also any case with regard to the reference made by the President to the Supreme Court under Article 143 of the Constitution. And it is not important that all the constitution benches have to be headed by the CJI. So these are the issues with regard to how a plea challenging the collegium system and few details about the collegium system. Now coming back to defection, so the Speaker Narwarkar of the Maharashtra Assembly, the case which was pending from so long with regard to the disqualification of the Eknath Shinde camp and also some members of the Uddhav Thackeray camp. So we know in 2022 the Uddhav Thackeray camp of Shiv Sena split into the Eknath Shinde's camp and also the Uddhav Thackeray camp. Eknath Shinde claiming to have a majority, and he went on to form the government in the Maharashtra. Now the Speaker Narwarkar is deciding on the disqualification petition, and he came up with some important issues. Let me tell you that according to Article 102 Clause 2, which deals with the anti-defection law, it is the Speaker who decides on on the disqualification with regard to the members of the Lok Sabha, and the chairman or the vice president who decides on the disqualification with the members of the Rajya Sabha. Now, Narwarkar said that the real faction of the Shiv Sena was the Eknath Shinde Shiv Sena, which were the rivals who emerged in June 2022, and he also rejected the disqualification petitions filed by the 30 Shiv Sena MLAs from both the factions, including Shinde himself, citing that there was lack of valid grounds for disqualification. Ruling out his ruling on disqualification petitions filed by the rival factions against the other MLAs, Narwarkar said that Sunil Prabhu, who belonged to the Thackeray faction, had ceased to be a whip from June 21st, 2022, and Bharat Gogawale of the Shinde group had become the authorized group. Now, in June 2022, Shinde and several other MLAs rebelled against the Chief Minister Thackeray and led to a split in the Shiv Sena, which had been founded by late Bal Thackeray. It also led to the fall of the ruling coalition Mahavikas Aghadi, which was comprising the NCP, Congress, apart from the Shiv Sena. So, rejecting the Thackeray's faction request to disqualify 16 Shinde faction legislature, Speaker said that there is no valid ground to disqualify them, and he has the power to decide on disqualification, saving the government of the day and also the MLAs of the Eknath Shinde faction. No party leadership can use the provisions of the 10th schedule for dissent or discipline within the party. This is what he said. He also rejected the disqualifications of 14 MLAs of the Thackeray faction, as the whip was not physically served on them. In fact, the Speaker dismissed all the petitions, saying that no MLA is disqualified because of lack of evidence. And the Supreme Court had directed the Maharashtra Legislative Assembly Speaker to deliver his judgment on the disqualification petitions filed by the rival factions as soon as possible, because the state is going to go to assembly elections in the late second half of 2024. And let me tell you that though the Speaker has the power to decide on the disqualification with regard to defection or anti-defection law under 10th schedule of the Constitution or Article 102 Clause 2, under the Nebam Rabia case in 2016, the Supreme Court clearly said that if the Speaker is also facing disqualification, he will be disabled from deciding on the disqualification petitions under the anti-schedule law or the 10th schedule of the Constitution if the notice for their removal is pending. And moving on to the next most important issue is with regard to the only 30 NGOs recently got the clearance for the Foreign Contribution Regulation Act registration. So in all, 30 NGOs and associations have been granted FCRA registration in the first month of 2024. Last year, a whopping of 1111 NGOs were granted permission to receive foreign donations, the highest since 2014. Voluntary organizations, NGOs, play a very active role in development of the nation by supplementing the efforts of the government, and NGO Darpan is maintained by Niti Aayog to enable the NGOs, non-profit organizations, voluntary organizations, civil society organizations, non-profit companies, charity organizations, registered societies, trusts, etc. to sign up to the NGO Darpan portal. And when you sign up to that portal, you get a unique ID which is mandatory for all the entities seeking registration under the Foreign Contribution Regulation Act of the FCRA, which is very important for them to get donations or contributions from foreign countries. The FCRA was enacted in 1976 with the prime objective of regulating acceptance and utilization of the foreign contribution and foreign hospitality by persons and associations working in important areas of national life. Now, foreign contributions are illegal for the members of legislatures, political parties, as well as official government officials, judges, journalists. However, the Ministry of Home Affairs recently amended the FCRA in 2017 through a finance bill mode and allowing political parties receiving contributions from foreign firm's Indian affiliate or a foreign company in which the India owns 50% or more of the shares. Now, FCRA registration is valid for 5 years, and NGOs are required to apply for renewal within 6 months when the registration expires. Now, the government has the authority also to cancel the FCRA registration of any NGO, including violation of Act and lack of reasonable activity for the chosen field, etc. And once cancelled, then the NGO will be ineligible to re-register for 3 years. And what are the other options apart from FCRA to receive foreign funding? An alternative option to receive foreign funding is nothing but the organization or the entity has to be registered under the Societies Registration Act of 1860, Indian Trust Act of 1882, Section 25 of the Companies Act of 1956, which are used to register the association, and they have to inform the RBI of receiving foreign contributions. And recently, yes, so the issues I've already touched on the remission policy of the 11 convicts and Bengal. Now, Mamata Banerjee has asked the government to include Bengali language in the classical language status. Only 6 languages in India. Classical language is not involved in the constitution. Constitution does not speak about classical language. It only speaks about the 8th schedule, that are the 22 languages, and also official language status and development of Hindi language. So, classical languages is something that was created by the Ministry of Culture. 6 languages, Tamil, Telugu, Sanskrit, Kannada, Malayalam, Odia, have been given the status of classical language. The very first language that got the classical language status is Tamil. Tamil was declared in 2004. Classical language is a language that is with an independent literary tradition and a large and ancient body of written literature. Indian classical language or Shastriya Bhasha is an umbrella term for languages having high antiquity, valuability, originality, distinct literary heritage. Now, the Republic of India recognizes 6 classical languages since 2004, and I've told you the list. So, this was instituted by the Ministry of Culture along with Linguistic Experts Committee, and the criteria for inclusion in a classical language is high antiquity of earlier text or recorded history of 15,000 to 2,000 years old, and I doubt Bengali has this history or this period of history with regard to antiquity of text. A body of ancient literature or texts which are considered very valuable by generation of speakers. Literary tradition be original and not borrowed from other speech community. Classical language and literature being distinct from modern. There must also be a discontinuity between classical language and later form of its offshoots. And the next most important issue is with regard to minority institution. Now, the Supreme Court is deciding on the minority status of the Aligarh Muslim University and said that just because an institution is being administered by another community and not a minority community, the institution does not lose its minority status. Now, a 7-judge bench is hearing references with regard to minority status of the Aligarh Muslim University. Article 30, let me tell you, constitutes minorities the rights to establish and administer institutions. A 5-judge bench in the Aziz Basha versus Union of India in 1967 held that AMU or Aligarh Muslim University was a central university and cannot be considered as a minority institution. The university was established in 1875 and got its minority status when the Parliament enacted an AMU Act in 1981. In 2006, the Allahabad High Court struck down the provision of the 1981 law by which the university was accorded minority status. The issue then was referred to a 7-judge bench of Supreme Court in 2019. Now, Supreme Court observed that the right to religious and minorities to establish and administer their own educational institutions is a right under Article 31 of the Constitution, and this was not to ghettoize them. So, just because of the administration is carried on by other committees and not the minorities, the institution would not lose its minority status. The minority character of the education institution is not lost if the founders who belong to a particular minority community choose administrators from other minorities. Let me tell you, minorities is not defined in the Constitution. It is defined under the National Minorities Commission Act, under which we have 6 minority communities, that is the Christians, the Muslims, the Sikhs, the Buddhists, the Jains and the Parsi community, and these minorities can establish religious based minorities and also linguistic based minorities have the right to establish and administer educational institutions according to Article 30 and Article 29 of the Constitution. Article 30 does not mandate the administration of a minority institution should be only by the members of that community. The provision confer the minority the discretion to choose the administrators of the institution. And with regard to the national character, the centre contended that the AMU cannot be considered a minority institution given its national character. The government said that AMU was not and cannot be a university of a particular religion or a religious domination. It said that the university declared as an institution of national importance cannot be a minority institution. The university had contended that it was established by the Muslim community for educating and empowering the Muslims. The petitioner challenged the 2006 judgment of the Allahabad High Court holding that Aligarh University cannot be considered as a minority institution because it was never administered or claimed to be administered by minority community despite being established by a minority community. The bench is also dealing with legal questions of designating a centrally funded university as a minority institution. The matter was referred to a 7-judge bench in 2019, which was headed by Ranjan Gogoi, who was the Chief Justice at that time, and now it is being continued to be heard. So this is what the Supreme Court said, that just because if it is administered by non-minority communities, it does not lose the status, and also it is a right for the minority to establish a minority institution, and they are not left to the behest of a law by the parliament or the state legislature, and they should not be discriminated with regard to funds that the central government gives to education institutions as well. So this is all with regard to your polity and governance for the week gone by, for week 2, that is January 7th from 12, and I shall see you tomorrow with my week 2 economy for the week gone by from January 7th to 12, and I hope this was really helpful to you all, and if you did, please do like, share, subscribe, and do not forget to comment, and I shall see you in my next post. Until then, as usual, very happy learning.